Okay, there we go. Hi, everybody. Thank you for coming. I appreciate you being here. This is an onboarding session fundamentally for students from Pro Bono Students of Canada. And Angelica is there. Thank you for being here. And there's some students from Youth for Innocence who are here for the most part as a learning experience, although there may be some participation by these students in the future, but it's fundamentally directed at those from Pro Bono Student Canada at Western. All right, so we're going to go through a number of things. Well, first off, I'm Miles McClellan, so I'm the Executive Director of Miscarriage of Justice Canada. So we're going to go through a number of things today just to get you familiarized, firstly with the field of endeavor, which is wrongful convictions. So we're going to have, and I've sent to you already, a PowerPoint that deals with the systemic causes of wrongful convictions, and then that will move into essentially the creation of the Miscarriage of Justice Review Commission, which in turn has prompted the creation of Miscarriage of Justice Canada, of which we are here involved with today. All right, so I'm going to share my screen. But before I do that, are there any questions? Is there anything in particular anybody wants to make sure we cover before we start? Are we good? Angelica, do you want to say anything?
No, but thank you for organizing this, and thanks to the Western students for coming on a Saturday morning, and for you for hosting this, Miles.
My, my pleasure. Okay, so let me share my screen. Okay, so okay. So can everybody see that? That's the beginning, the first slide in the PowerPoint. I see some nods, so that's great. So thank you. And I'll keep track, of course, of people who still want to get in as well. Okay, so this is a PowerPoint presentation. It was originally created about a little less than 2 years ago for an initial presentation before the House of Commons Justice Committee on Justice and Human Rights. And its focus at that time was basically how we saw the new commission, which wasn't in place at that point. It's not in place technically yet at this point either, and I'll explain that a little later. But as in preparing for the legislation to be enacted to create the Miscarriage of Justice Review Commission, which was actually passed on December the 17th of last year, there was committee meetings at the second reading of legislation in the House of Commons. So I appeared then, and a lot of this presentation is for that appearance before the Justice Committee, and a lot of it deals with, or some of it deals with, the overrepresentation of Indigenous and Black in the criminal justice system, and the underrepresentation of them in the exoneration process, and that's what this was directed at. But in any event, we're going to deal with basically, to begin with, the causes of wrongful convictions, and then we'll move to the numbers of wrongful convictions that exist and the numbers that we will see likely going to the MJRC, which I'll deal with next. And then lastly, the role of Miscarriage of Justice Canada in the new, what if that in fact is a new arena for exonerations in Canada. All right, so let's see here. Go back. So apart from the abolition of capital punishment worldwide, which still exists in a number of places, there's 34 states in the United States of America that still have capital punishment, plus a number of other countries around the world, China and what have you. Canada abolished capital punishment in 1976, although the last person who was hanged in Canada was in 1961 at the Don Jail in Toronto. All of the capital cases from 1961 to 1976 were commuted to life imprisonment. So apart from that issue, which is an incredibly important issue, obviously worldwide, the next most important issue generally has been accepted to be wrongful convictions. And in Canada, wrongful convictions have been well established through the publication of 7 public inquiries into specific cases that have become universal. These are the names of those inquiries. The first one was Donald Marshall. You have Guy Palmeran, Thomas Sofino, Ron Dalton, James Driscoll, David Milgaard, and most recently, which is now 2012, the investigation into forensic pathology, which dealt with the Dr. Charles Smith, or the former Dr. Charles Smith's egregious errors in, for the most part, pediatric pathology. The causes that are recognized now universally worldwide that create wrongful convictions are these, and we're going to talk about these in more detail. Tunnel vision, mistaken eyewitness identification, false confessions, jailhouse informants, ineffective defense counsel, prosecutorial misconduct, and faulty forensic evidence. All right, so these and all of these evolved through the process of those public inquiries that Canada had to basically determine that these pretty much across the board are the causes of wrongful convictions, right? And then, when somebody in fact is seeking exoneration, they're going to be pointing at one or more of these that said that this led to, in fact, my wrongful conviction. The first one is tunnel vision. Tunnel vision isn't in itself is a systemic cause. It's basically something that occurs almost in all of them, but it's incredibly important to put it up at the front. So tunnel vision is, as it says here, a single-minded and narrow focus by the police, sometimes the prosecution, on a particular investigative or prosecutorial theory so as to unreasonably color the evaluation of information received and one's conduct in response to that information, which essentially means that when the police see somebody that they like for the crime and they believe internally that that person, in fact, is the one that committed the crime, then what they tend to do is they focus virtually all of their efforts on proving that person was, in fact, the perpetrator of the crime, and they don't look at any evidence that could be exculpatory leading away from that person's, in fact, guilt. Things like other kinds of evidence or alibi evidence or what have you. So tunnel vision is a narrow focus on somebody. And once the police do that, it's almost impossible to turn them away from eventually charging that person. So the evidence is basically incorrectly filtered and it creates a biased approach. This is often reinforced as police and prosecutors who are assigned to the case interact with the evidence in what is not, in fact, a critical assessment, right, and doesn't properly test investigative theories that would lead to other potential people who would be, in fact, the actual perpetrator. So high-profile criminal cases, particularly those involving gruesome facts, and you guys would probably know this is common sense, tend to inflame passions and create intense pressure on the police to arrest as quickly as possible. This in turn intensifies pressure on the investigators to identify a viable suspect, and very often that suspect is somebody who's already in the criminal justice system, so that's somebody who already has a record for something, so the police see them as being bad people to begin with. And speed, as in speed to in fact make an arrest, becomes an overriding factor and tunnel vision sets in. All right. Police often use race as indicators for patrols, arrests, and detentions. For example, police in cities tend to patrol bars and streets where Indigenous or people of color congregate rather than private clubs where the white population meet. And these are very generalized statements, but these aren't things that I'm making up. These are statements and facts that have come from all of these public inquiries in Canada. All right, Donald Marshall Jr., he was the very first person who led to a public inquiry in Canada. He was wrongly convicted of murder in 1971 and released 12 years later on the basis of new evidence. And there's a picture of him. He's now passed away for about 6 or 7 years now. The case was again the first public inquiry into wrongful convictions in Canada. His case was also a clear example of how an Indigenous accused, right, and he was Indigenous, was racialized in the criminal justice system by the police, by the Crown, and even by the courts that heard the case. And after the trial, one of the jurors who in fact convicted him, this is highly unusual because jurors aren't supposed to do this, but here's what one of the jurors said. With one red skin and one Negro involved, it was like two dogs in a field. You knew one of them was going to kill another. I would expect more from a white person. We are more civilized. Believe it or not, that was something that was actually said by a member of the jury who wrongly convicted Donald Marshall Jr. The ways where the criminal justice system systemically discriminates against indigenous people are that indigenous accused are more likely to be denied bail, they spend more time in remand custody, that's custody without being sentenced, and are more likely to be charged with multiple offenses. The impact of over-policing has led to a great distrust of the police by indigenous, Black, and marginalized individuals. Over-policing, again, a function of tunnel vision, also leads the police to forming attitudes that these groups are violent, dangerous, and prone to criminal behavior. According to provincial court statistics, 22% of Indigenous persons appearing in provincial court faced 4 or more charges, compared to only 13% of non-Indigenous accused. And at the other end of the scale, while 50% of non-Indigenous accused faced only 1 charge, this was true for only 37% of Indigenous accused. All right, so that's an overview of tunnel vision and how it unfairly basically focuses on somebody who may well be innocent, but who will, in fact, almost inevitably lead to being charged and convicted. Mistaken eyewitness ID is the next systemic cause. It is, in fact, the most, and I would say it's the most, it shouldn't say the most important because tunnel vision is probably the most important overall factor. But apart from tunnel vision, mistaken ID is the most important factor leading to wrongful convictions because they occur in upwards of 80% of all wrongful convictions. All right. And these, of course, involve cases where somebody, whether it's a witness or in fact the victim of a crime, will identify the person who they believe is the perpetrator. The danger associated with evidence, with this kind of evidence, is that it's highly credible because it is seen as both honest and sincere. So put yourself in the position of being on a jury. You're at the trial. The witness or the victim is on the witness stand. They're asked if they can identify the person who committed the crime, if they are in the courtroom, and they inevitably point to the accused. If you're a jury and you see that happening, right, and it's highly likely that they're going to do it with a fair amount of confidence, then you are not going to believe anything that the defense has to say that turns away from the fact that they have been identified as the perpetrator. There are a number of factors which affect memory, which basically should take into account when somebody's assessing the viability of a witness identification. Some of them are obvious, like the state of lighting or the time of day when a witness observes an incident. Witnesses almost always think that an event takes place over a longer period of time than it actually does. There is also a weapons focus, where witnesses will remember a weapon used during the commission of a crime to the exclusion of other details, including identifying the accused. So just think about this, and it just makes a lot of sense. If you are within a very close proximity to a crime taking place, firstly, you're going to feel yourself in danger. There's no question about that because they're going to be in some form or another a weapon, whether it's a knife or a gun. So if you are in close proximity to somebody who's wielding one of these weapons, you're not looking at potentially the person that they're being wielded at more directly. You're looking at the weapon itself to make sure that it doesn't end up being turned around and used on you or pointed towards you. So, in a witness ID, and there's almost always a weapon involved, right? You're not focusing on what the person looks like who may in fact be, the perpetrator. You're looking at somebody who's actually wielding it, right? Witnesses will often be able to describe the gun or knife accurately to the detriment of their ability to describe the person holding the weapon. And that's just kind of common sense. And there is also being shown to be a very weak correlation between the confidence level and the accuracy of a witness testimony, which means essentially that and this is proven over the course of time and as a function of a number of studies. It's proven that a witness in a witness box who shows a lot of confidence in identifying the perpetrator basically by pointing to them in the courtroom saying, yes, that's the person that did the crime, right? The more confident they are in that belief, chances are the less likely they are correct in making that identification. And it has a powerful effect on jurors in that they tend to believe that the confidence in a witness equates to believability, right? And for Indigenous and Black accused persons, studies have shown that cross-racial eyewitness ID is particularly difficult. A Caucasian witness will more than likely have a difficult time identifying an Indigenous or Black suspect correctly. Police can also provide an intentionally prejudicial person in a lineup for suspects. And the case involves Jason Hill. And I'll tell you about this. This is a very important case in Canada. So Jason Hill was a young Indigenous man. This is back in the 1980s and early 1990s. And he lived in Hamilton, Ontario. And a number of corner stores where, nowadays there's Circle K or what have you, were basically being robbed by somebody who would come in and point a weapon at the clerk behind the counter and take their money. And this happened 10 or 12 times in a fairly quick succession. And almost invariably, the person who basically was being robbed said to the police when they were asked, they said, we think that the accused or the perpetrator was Indigenous, right? That was the belief they had, or that was the belief that most of them had. So having said that, the police in Hamilton liked Jason Hill for the crime. Jason had already been on their radar, and I indicated this earlier. He already had a record, right? So he was already in the system. So, that automatically makes police believe that this person is capable of committing crimes and is in fact a bad person. All right. So they arrested Jason Hill. They charged him with all 10 or 11 counts of robbery. By the time it got to trial, they'd actually reduced it to one. But here's the evidence that they put in front of the jury to convict him of that one. They created a line, it's called a personal array, a lineup. Now you see this in TV and movies all the time. They don't exist anymore. But somebody stands on one side of a glass partition, and behind the glass there's 10 or 11 or 12 people, and they're asked to identify. Do you see the person who pointed the gun at you in the store? Is it number one, two, three, four, five, what have you? So in Jason Hill's case, right, they put him into a lineup. The police knew that all of the people who were robbed indicated that the person was likely Indigenous. So they put him in a lineup of 12 people, 11 Caucasians and one Indigenous person, him, right? So there was no question whatsoever that that's a prejudicial lineup, right? And that's how they identified him. And that was the evidence that convicted him. Now, as it turned out, after, and he was in 2 or 3 years into his prison sentence, the police found out that, in fact, more robberies were still being committed, right? And in fact, they eventually caught the people who admitted to doing the robberies that, in fact, Jason Hill was in prison for. So he was released. What he did, and this is why the case is incredibly important, apart from that incredibly prejudicial lineup, is that he sued the Hamilton Wentworth Police Service for negligence, basically saying, look, that lineup was clearly negligent. It shouldn't have happened that way. It should have certainly, there shouldn't have been just one Indigenous person that who was clearly going to be identified as a function of the facts that the police knew. And it went all the way to the Supreme Court of Canada. And the Supreme Court of Canada, in fact, agreed with them that, in fact, that negligence for police in doing their investigative work is a cause of action. So they recognize that cause of action. And the important part of what that is that Canada is the only common law jurisdiction in the world that recognizes that police can be sued for negligence. Every other common law jurisdiction, all the states in Australia, New Zealand, and the UK, and what have you, they all give police immunity from prosecution or being sued for negligence. But Canada has it available. And then, believe it or not, in the Supreme Court of Canada heard this decision in 2007. And there have been hundreds of cases in Canada since then. And the success rate is fairly high. The success rate is about 33% in people basically being successful in suing police for negligence. So it's incredibly important. The sad thing for Jason Hill, having done all of that and gotten all the way to the Supreme Court of Canada, is that while the Supreme Court of Canada said, yes, we will recognize negligence as a cause of action, back in 1995 or whatever it was, when that lineup took place, the Supreme Court said, yeah, you know what? It wasn't an ideal lineup, but it wasn't uncommon for police to do that back in the day, right? And as a function of that, basically, while it could have been negligent behavior, it wasn't deemed to be particularly negligent at the time because it was a common practice for police. Right? Today, that wouldn't happen. Today, all the courts would basically find that that kind of thing was negligent. But back then in 95, the Supreme Court said, yeah, we're going to recognize this cause of action, but we're not going to apply it to Jason Hill's case because the police did what other police do at that time, right? So that's what makes that case incredibly important. All right. The next systemic cause of wrongful convictions are false confessions, right? They're found in approximately 25% of all wrongful convictions, right? which is very counterintuitive because people don't tend to believe that, you know, somebody would falsely confess to a crime they didn't commit. And recantations are useless. So what essentially means is that if somebody, and we'll talk about why they may confess in a minute, but if somebody confesses to a crime they didn't commit, and they almost immediately turn around and recant that, saying, "I didn't mean that. I am not guilty. I didn't mean to admit that I was guilty." That is essentially useless because once a jury hears that somebody has in fact agreed or indicated that they were in fact guilty for a crime, then that is what sticks with the jury, right? They don't care how many times that person may turn around even minutes later and saying, "I was wrong, I didn't mean to say that," or they may say it days or weeks later. Doesn't matter how much they recant the confession. If the confession is made at all and it gets before a jury, then it's going to lead to guilt, right? Police have long known that suspects will admit to crimes they did not commit for several reasons, including mental illness, desire for attention, desire to protect loved ones. There's a number of causes for it. More often than not, however, a suspect will give in to a false confession in order to escape the punishing experience of an interrogation. Extended pretrial detention leads to false confessions, and for example, leading to, basically agreeing that they're going to confess to a crime if they're serving time, and the time will come to an end if they confess, right? And here's a really important part about that is that, confessing to it is almost always a function of abusive interrogations, which the Supreme Court of Canada basically does not have a real problem with. While the charter basically allows those who are accused of crimes to speak to a lawyer and to remain silent, when somebody's arrested, they will be given the opportunity to speak to a lawyer. Usually, they don't have one at their fingertips, so they'll be given a phone call to a legal aid lawyer who's on duty, particularly, and so their conversation with that duty legal aid lawyer is going to be pretty cursory and not particularly helpful, and that's it, right? They no longer have a right to have a conversation with a lawyer, which is totally opposite to other jurisdictions. Many states and the UK basically give accused the rights to have lawyers basically present with them during an interrogation. Canada doesn't do that, and the Supreme Court of Canada doesn't require that. Likewise, a person can basically invoke their right to remain silent as many times as they want. They can do it 5, 10, 20 times. It doesn't matter how many times it is. The police can just simply override that and keep interrogating them as long as they wish. And there's no time limitation as to how long the interrogation can take. So as you can imagine, and there's a number of cases where this has happened, where they've been interrogated for 5, 10, 15 hours. They're exhausted. They often give them, they give them soft drinks, Coke with caffeine, right? They have, makes them have to go to the washroom and they don't let them, right? Or they extend the time before they let them, which again creates a very unpleasant experience for them. And what happens is that people, and again, these are recorded in the public inquiries that we've seen and all of the wrongful conviction research, people will in fact confess if it will just end that interrogation for them, right? They're living in the moment. They just want to make that punishing experience come to an end, and not worry about what that leads to down the road, right? Indigenous population overall are at the bottom of almost every index with respect to educational levels, employment opportunities, housing conditions, per capita incomes, and those in fact become self-fulfilling prophecies for pretrial detention because factors relevant to release on bail include whether the person is employed, has a fixed address, is involved in educational programs, and has strong links with the community. So what that means, again, going back to time served, if somebody basically has been denied bail and and it takes quite a while to get to trial these days. If you're going to be looking at spending an inordinate amount of time in remand custody, which is not convicted of any crime, but not allowed to have bail, so you're going to be in jail until the trial, people will confess basically if they can get out for time served, right? That's a false confession just for that particular purpose. And again, this is the same thing. People being denied bail often leads an accused to pleading guilty to end time in jail without regard to being guilty or innocent. And here's some more stats. Studies of provincial court data reveal that Indigenous charged accused were 1.34 times more likely to be held pretrial detention, which is 55% versus 41% of non-Indigenous charged people. Of adult males between the ages of 18 and 34, Indigenous persons spent approximately 1.5 times longer than non-Indigenous in pretrial detention. Indigenous women charged 18 to 34 were 2.4 times more likely to be held in pretrial detention versus non-Indigenous charged women. And more people now spend time in jail waiting for trial than due to sentencing after conviction. So this is a chart I prepared for an article I published. Now it's 15 years ago, but I can tell you the numbers haven't changed, or the trajectory of the numbers hasn't changed very much since then. So what this chart basically shows this. Back in 1982, which is the first line you see on the left, right? You'll see the yellow triangles, remand custody. So those are people in custody who have not been granted bail, but are still presumed innocent, was down around the 48,000 persons. This is in all the provinces and territories across the country in the year that I did this. So 1982, about 42,000 people remand custody, and about 115,000 people were in sentence custody, and that's those red dots. And then you track all the numbers going forward for the next 22 years. So when you get to 2004, you can see that the numbers have totally flipped in that basically in 2004, the number of custodial sentences was down to about 62,000, but the number of remand cases was up to about 118,000, right? A complete reversal of the people who were and these are mostly provincial jails, because that's where you do your time if you're denied bail, but you haven't gone to trial. And that's what this pie chart is. 64% of all custody inmates were in remand custody, again, presumed innocent, not a trial yet, and only 36% are in sentence custody. So 2/3 of everybody, this is back when I did the study, were in remand custody. The numbers are now have now climbed to 70 to 80% of all inmates in remand custody basically are in remand custody, and only 20% or less are in sentence custody, right? Which tells you that a great number of people are being held on bail and not being released. And again, as a function of that, people will plead guilty to bring that to an end. In the US and the USA, under the National Registry of Exonerations, which includes over 3,000 people who have been wrongly convicted since 1989, 800 of those were false confessions. All right. The newly formed Canadian Registry of Wrongful Convictions, which was created by Professor Kent Roach at U of T, he created this about 3 years ago. Of the 83 cases they had at the time I created this slide, which again is about a year and a half ago, of 83 people registered as wrongful convictions in Canada, 15 of them had in fact falsely confessed. Of those 83, 73% of these false guilty pleas were made by women, Indigenous, or racialized persons. So that's an incredible disproportionate number in that regard. Okay. The next systemic cause are jailhouse informants, right? And here's a quote from the inquiry into Thomas Sofino. He was wrongly convicted in Winnipeg. So here's what his public inquiry, the justice who was conducting the inquiry, said. Jailhouse informants comprise the most deceitful and deceptive group of witnesses known to frequent the courts. The more notorious the case, the greater the number of prospective informants. They rush to testify like vultures through rotting flesh or sharks to blood. They are smooth and convincing liars, right? And before we move on, here's what this is. So somebody has been arrested, and who the police obviously like, the function of tunnel vision. They like somebody for a crime, and they're in jail, and they've been denied bail at some point, so they're there, and they're waiting for trial more likely than not. But the evidence is incredibly weak against them. They like the person for the offense. They believe they're guilty of the offense, but they don't have a confession, all right? And they don't have an eyewitness testimony that they think they can rely upon, which is, again, quite common. So what they do is they put somebody in the cell with them. It's more often than not a police officer, basically covering or pretending to be another inmate in remand custody, right? Or in the alternative, they find somebody who is in fact an actual accused in remand custody, and they put them in the cell with them, right? And not the police officer so much, but other people who in fact were already in custody for a crime they likely committed, basically go into the cell, and then in a relatively short period of time, they will come back to the institution, the jail where they're being held, and to the police officers who laid the charge and say, yeah, I was in this cell and I was talking to John, and he confessed to the crime. And he'll basically make up details of it, right? And that is the evidence that will be used that goes before the jury, right? The person that they're a jailhouse snitch, they will in fact be put on the stand, and they will, basically fabricate the story of the confession they heard from the person who's accused of the crime that in fact didn't do it, right? So this is an incredibly egregious type of systemic factor, but it happens. The only thing that protects the accused against this is that this kind of testimony basically requires what's called a Vetrovic. That's the name of the case. So a Vetrovic warning has to be given from the judge to the jury that basically says, take whatever this person says with a grain of salt, because he's an accused person convicted of a crime, and so his evidence may well not be that credible. All right, and that's as far as it goes. This testimony is still allowed. All right. Next, we have ineffective defense counsel. Right, the Aboriginal Justice Inquiry in 1999 in Manitoba found that Indigenous accused persons spent less time with counsel and relied upon duty counsel more than non-Indigenous persons. Indigenous accused are more likely than non-Indigenous accused to appear in court without a lawyer, while 61% of Indigenous accused saw their lawyers 3 or fewer times. 63% of non-Indigenous accused saw their lawyers 4 or more times. 48% of Indigenous accused spent less than an hour in total with their lawyers, compared to 46% of non-Indigenous who saw their lawyers for 3 or more hours before trial. And again, this goes back to those who are in remand custody to a great degree, which again are unrepresentably more with Indigenous peoples and marginalized accused. So what this means essentially is that there's less time spent with a lawyer before you get to trial, and that is particularly the case if you're in remand custody. If you're not on remand custody and you in fact have been granted bail, then it depends upon how, if you don't have the funds to mount a defense, and it's a very expensive proposition to do it on a private retainer, then you're going to be doing it with somebody on legal aid. So that again will limit the time spent with the accused, because the legal aid has very precise time limits spent for each stage of preparation for a trial, right? And the less time you spend with a lawyer, the less prepared they're going to be to mount a defense that's going to in fact prove that somebody who has already been identified by the police as guilty, to basically reverse that and lead to a finding of it's not innocence, it's non-guilt at trial. So it's very, very difficult. The lack of time spent with a lawyer has significant consequences for how an accused is dealt with in the system. Again, because the lawyer may be less informed about the circumstances of the offense, the potential defenses, and the resources available as alternatives to detention. All right, so inadequate defense counsel, which could either be the lack of access to counsel, or it could be the lack of time spent with an accused by counsel. These are the things that have in fact become systemic causes of wrongful convictions. All right, next we have prosecutorial misconduct, right? And this revolves again tunnel vision and jailhouse informants. So when the police, from the point of tunnel vision, identify an accused as somebody who they believe is guilty, even though they're wrong, the Crown will tend to buy into that, right? They believe for the most part that the police do their investigative work well, right? So they'll buy into that, and they will in fact become part of that tunnel vision syndrome. And likely with jailhouse informants, that's not going to take place unless it has the Crown's consent, right? So in order for a jailhouse informant to be put into the cell of somebody who is believed to be guilty, but of course we now know is not, the Crown will be in on that. They'll be familiar with that going on. And so they are part of these things that in fact lead to wrongful convictions. Most importantly, however, we have what is called the issue of non-disclosure. So in 1991, the Supreme Court of Canada basically rendered this decision. It's now Rex versus Stinchcombe, which basically indicated that the Crown is obliged to do the following. Um, and in this case, the court found the Crown had a duty to provide the defense with all evidence that could possibly be relevant to the case, regardless of whether the Crown plans to call that evidence at trial or not, and whether or not the evidence helps or hurts the Crown. That is what is required of disclosure. Disclosure is now constitutionalized by Section 7 of the Charter. So if basically the Crown doesn't provide appropriate disclosure, it is a breach of the Charter. Okay. And I can tell you right now that in Miscarriage of Justice Canada, we now, although we've been operational for about a little less than 2 months, we have now 8 files already, and we already have seen non-disclosure as the cause of some of the wrongful convictions we're looking into. So that case, Stinchcombe put to rest the long-standing issue of whether the Crown could purposely deny defense evidence evidence that was harmful to the Crown's case, right? But having said that, we still see it, right? And we still see it, and it's now a charter argument, and it is recognized by the inquiries as a systemic cause of wrongful convictions, right? And lastly, we're dealing with faulty forensic evidence. And it is important I mean, people, when they think about forensic evidence, they think of, wow, I mean, if that's available in the case, then it's going to be a slam dunk. But it's not always, all right? Now, it's widely recognized that DNA analysis provides the criminal justice system with persuasive evidence to investigate and prosecute crime, and that's absolutely true, okay? So it has both a great potential to convict the guilty and to exonerate the innocent, right? And it's a wonderful thing, in fact, if it's available, but it's only available in 10 to 15% of cases, right? So only in cases where there is, in fact, biological material at the scene of the crime that can be examined will it have value. And that's where that number comes from there, right? And that, for the most part, is only going to take place in crimes where there is, violence and physical contact. So things like homicides, sexual assaults, what have you. So for basically 80 to 85% of all cases that don't have DNA, then you don't have that specific kind of forensic evidence to rely upon. We formerly had the use of what was called hair and fiber comparison evidence, which for over 50 years has convicted thousands of individuals now dismissed as junk science. In a very famous inquiry, the Guy Paul Moran inquiry, the evidence included, and he actually ended up having 3 trials as a function of overturning on appeal before he was exonerated with DNA. But during those trials, the second trial actually, hair evidence was put into the record by a alleged specialist in this kind of hair and fiber analysis. And it was indicated that hair, which was found at the scene of the crime, which was the murder of a very young girl, Christine Jessup, 8 years old. She was found dead in the woods, a fair distance away from where the accused, Guy Pomeran, lived, but she was his next door neighbor. And hair was put into evidence that hair found at the scene was comparable to Guy Pomeran's hair. And as it turns out, at the end of the day, when it was properly analyzed by certainly a better lab than the one that gave the evidence, the hair, in fact, was dog hair, right? So, hair evidence is junk science. Bullet striations, and sometimes you see this in, again, movies and TV where somebody will have a bullet and found at the scene of the crime, and they will look it under a microscope and it has striations, in the metal, and they'll compare that to a rifle or a gun that the accused owns, and they'll indicate that in fact that bullet came from that gun because the striations match the barrel. That's junk science. That just inevitably is going to be wrong, or more often than not is going to be wrong, right? And that type of evidence has led to wrongful convictions of hundreds of individuals. Any questions so far? Okay. All right. So those are the systemic causes. So that gives you a pretty good idea of what we're looking at when we're looking at people who apply to us for miscarriages of justice. And the term miscarriages of justice is used interchangeably with wrongful convictions for the most part. So for our purposes anyway, and so that gives you a pretty good idea of what we're going to see when people apply to us to see if in fact they have been wrongly convicted. We will see some combination of any of those systemic causes that we just went through. All right. Now, when it comes to the number of convictions and how many may be in fact be wrongful, right? The social scientific evidence over the last 20 years has estimated that anywhere between 0.5% to 5% of all convictions are wrongful. Right now, the reason it's social scientific evidence is that it's not um, factual evidence. It's not solely scientific evidence. It's done by criminologists and other experts in criminal justice who basically estimate how many wrongful convictions there could be. If we wanted to know exactly how many there factually were, we'd have to look at every single conviction individually and assess the merits of the conviction itself. And there's hundreds of thousands of those every year. So that's just not going to happen. So what social scientists like criminologists do is they interview defense counsel and crown counsel and judges and other participants in the criminal justice system and get their best estimate of how many wrongful convictions they are personally familiar with, right? And they use that evidence and they extrapolate it into a percentage for all wrongful convictions. And what we're talking about for wrongful convictions are in fact those who were found to be factually innocent, as in they did not in fact commit the crime. So we're not talking about those who were convicted because there was a breach of the charter, for an illegal search and seizure, that kind of thing. We're not talking about that. We're talking about factual innocence, right? And for the purposes of this presentation, we'll accept that the estimate of wrongful convictions can be averaged out at, say, 3%. Okay, so what we're saying is that, and this is legitimate, 3% of all convictions that take place, this is whether it's in Canada or the United States or the UK or Australia or New Zealand or whatever, because we all accept the same basic evidence when it comes to wrongful convictions internationally or universally, that anywhere between 1/2 to 5% of all convictions are wrongful, so we'll average it out to 3%, right? So if you look at Stats Can data in that regard, and so the last data, this is the data I used in my presentation initially. So as of 2022, there were 215,113 criminal cases in Canada. And that's a fairly consistent number. If you look at the last 10 to 15 years, the number has varied between 190 and 220,000 a year of basically individual cases where people are charged with crimes. So 215 in 2002 is an approximate number, but it's proper. And of those criminal cases, 47% led to conviction. So 101,839, in fact, convictions, and that's a fairly uniform number across the years, right? And then of those 101,000 convictions, 1/3 of them resulted in a custodial sentence. All right, in a custodial sentence, and you guys probably know this already, if you're convicted of a crime for 2 years less a day, you will do it in a provincial or territorial institution, so in fact a jail, right? If your sentence is 2 years or more, you're going to be spending your time in a federal penitentiary. And these custodial sentences deal with both of those, all right? And that's just a bar chart showing those numbers, right? And then again, out of the 33,197 cases where custody was ordered, 9,959 of those were Indigenous, so 30%, right? Okay. And of those convictions, 801 of those were in fact dealing with homicides, so that's first degree, second degree murder or manslaughter, which is 0.08 of the convictions, which is 0.24% of those in custody. All right. Okay, so wrongful convictions, again, we go back to that 3% number. So the total number of convictions in Canada in that particular year, 2022, of the 101,839 convictions at 3%, we know that, and this is a substantive number that we can rely upon, over 3,000. So 3,055 cases in Canada in 2022 that basically were held where somebody was in fact found guilty. Over 3,000 of those cases were wrong. There were wrongful convictions, all right? And of those cases, the ones that were in fact put into custody, that number is 996 individuals, so just under 1,000, right? So just under 1,000 individuals in 2022 were wrongly convicted and incarcerated, right? And that number is consistent. So that would have been very close to the number for 2021. It would be the number for 2024 if I pulled up that data, right? And as you can appreciate, 1,000 every year, and it accumulates, right? The numbers, add on to each other, those being released and those additionally being put into custody. And of those cases, homicides, 24 cases, each year in round terms are wrongful. So there are 24 homicide convictions each year that, in fact, should be exonerated. And you just apply that 30% percentage to Indigenous individuals, and 8 of those 24 would have been Indigenous accused, found guilty of murder or manslaughter. All right. Now we go to Innocence Canada. Innocence Canada, as you guys probably know, is the gold standard for wrongful conviction or integrity units in Canada. They're not the only one. I mean, we now, Miscarriage of Justice Canada is now a new one, but you also have a number of them at, various law schools. So UBC has an Innocence Project. Osgoode Hall has an Innocence Project. There's an Innocence Project at the University of Ottawa, but it's not the law faculty. It's in fact the Department of Criminology. So you have a number, Dalhousie has one. You have a number of innocence projects across the country that, in fact, work to exonerate individuals. Innocence Canada, however, is the oldest one and certainly the most successful conviction integrity unit across the country. It was created in the 1990s. It started dealing with the case of Guy Palmerin. I just discussed that with respect to the hair evidence. And so it's been around for 30 years. Originally, it was known as the Association in Defense of the Wrongly Convicted, or AIDWIC. It converted its name about 10 years ago to Innocence Canada. To date, it has about 35 exonerations under its belt, right? It only deals with homicides. However, in 2023, it received 34 new cases, right? And that's a pretty consistent number for new cases coming in every year. It currently has 55 active cases it's dealing with, which means it's dedicated. I think it has now 4 in-house lawyers dealing with it. It has a director of client services, Wynne Wayher, who's very famous in the field. She's a lovely lady. And it has 71 cases on the wait list. And these are homicide cases. So my understanding is, and I belong to Innocence Canada, I have for about 15 years, those 71 cases basically make up a queue of 4 years. So if you believe you were wrongly convicted of a homicide-related offense, again, first or second degree murder or manslaughter, and you believe you've been wrongly convicted and you want to make an application in Innocence Canada today to solicit their assistance, you're going to be waiting 4 years before your case goes from the wait list to an active list. All right, that's a long time. The process, and this is currently the process that is actually still in place, and it will be for the next few months, but the process that has existed for a very long period of time to exonerate somebody is under what's called Section 696(1) of the Criminal Code. And then we're going to see how that evolved to the Miscarriage of Justice Review Commission process. Right? So the current process is under that section of the Criminal Code. It's called ministerial review, and it's called ministerial review for a reason, because the Minister of Justice is the person that eventually is responsible to making decisions as to somebody who is seeking exoneration will in fact have available that particular remedy, right? The process goes back to 1892, which is the creation of the very first criminal code in Canada, right? And the process is there and involves exceptional requests, and they're exceptional for an extraordinary and highly discretionary remedy that derives from the royal prerogative of mercy, right? And that's a very old and anachronistic term, but it's the one that still applies. If you want to be exonerated, you're seeking the mercy of the Crown. So what happens is that the application goes to the Department of Justice, and there's 4 or 5 lawyers in the criminal conviction review group that look at these cases and interact with the person or the lawyer on behalf of the person who has applied for the exoneration under 696.1. All right, and they go back and forth, and then the CCRG, the review group, will make a recommendation to the Minister of Justice as to whether this should be looked at as something where a miscarriage of justice has likely occurred. So what happens is that if the minister gets that recommendation from his group within the Department of Justice, right? If they get that recommendation from the group, then the minister can do this. The minister may, again, it's totally discretionary, may make a referral to the Provincial Court of Appeal or order a new trial, and this is going to be in the province where the crime took place, if there is a reasonable basis to conclude that a miscarriage of justice likely occurred. That's important to recognize that term likely because it's now changed. But under 696.1, if the miscarriage likely occurred, then there will be a remedy, basically, and a finding that a miscarriage of justice has probably happened. It probably means virtually without, beyond a reasonable doubt. right? So ministerial process places a heavy burden on the applicants. The minister will not exercise the discretion to order a new trial or an appeal in the absence of new and significant evidence, right? And most applications are denied after the preliminary assessment. So new and significant evidence means the evidence can't have existed and wasn't available at the time of the first trial that led to the conviction, right? It has to be new. It has to be something that was not available. Right. So of course that means, if it took place, and we still have cases coming before the minister that are 30 years old. So if there was, for instance, biologic evidence that what couldn't have been tested back then because DNA analysis didn't really come into its own until the late 80s and early 90s. It didn't become very, very reliable until the 2000s. So if you had biologic evidence that wasn't or couldn't be properly tested back then, but today that evidence still existed and is now properly assessed under what are exceptionally strong DNA analysis efforts. If it could today be in fact used to basically say, look, that DNA found at the scene does not belong to the person who's applying for exoneration, right? Then that's new and significant. So that's a slam dunk. There's no question whatsoever. And many innocence projects. So for instance, the very first innocence project in New York, right? The one that you basically see in all the movies, the movies that have an innocence project referred to. It's the very first one that was created in New York by Barry Scheck. It has hundreds and hundreds of cases in its queue. It only looks at cases that have DNA, right? So that's somewhat disingenuous from our point of view because they only want cases that are in fact going to be a slam dunk if the DNA points towards exoneration, right? Most projects, including Innocence Canada and us, we don't restrict ourselves solely to DNA analysis being available, right? Because we believe that there are a lot of wrongful convictions, and obviously we know that a great many wrongful convictions take place without that kind of evidence being available. But having said that, without DNA, proving innocence becomes a pretty difficult proposition, right? So let's move forward. So on February the 16th of 2023, right, so that's now 2.5 years ago, the Liberal government, it was Justin Trudeau's Liberal government, introduced Bill C-40, which was an act to create a miscarriage of justice review commission in Canada. So this was a recognition at the time that the then system, which is still the current system under 696.1 of the code, was ineffective. It shouldn't rely upon the prerogative of mercy, right? And it shouldn't be so highly discreet and discretionary that the minister makes his decision in secret. He never gives the reasons why he made the decision for the most part. And that is just not a very transparent system and one that's fair to those who are seeking exoneration. So the title of the bill was not only is Bill C-40, an act to create a miscarriage of justice review commission, but it was also called David and Joyce Milgaard's Law, right? And this is because of essentially the work of David Milgaard and his mother Joyce, who in fact were well acquainted with the then Minister of Justice, David Lametti, who is the minister, in fact, who promoted Bill C-40. David Milgaard was wrongly convicted of murder. He spent 23 years in prison. He, in fact, was eventually exonerated because of DNA, but it wasn't until after 23 years of actually being in custody. And the only reason that his case actually made it to the minister's desk was to the efforts of his mother, Joyce Milgaard. And this is very, very often is the case that, those who are wrongly convicted, who profess their innocence, they still tend to keep their relationships with their family while they're incarcerated. Because the family, if they believe them or her, right, they believe them, right, is there to support them. And so while many, many people who are incarcerated lose their family and their contacts to the family, particularly if they're guilty and there's no question about the guilt, right, they often lose those contacts. Those who are innocent or profess their innocence tend to still maintain those contacts. And that was very much the case for David Milgaard. His mother, Joyce, basically was unrelenting in her efforts to see that her son was proven innocent. And in fact, she interacted with, at the time, Prime Minister Brian Mulroney. She actually put herself in his face at an event that he was attending to basically say, you must look at my son's case. And, he believed her and he turned to his then Minister of Justice, who was Kim Campbell, who became the Prime Minister after Mulroney for about 3 days. But anyway, he gave it to Kim Campbell, who was the Minister of Justice, and she was the one that basically agreed to open his case, which eventually led to his exoneration. And that's why the bill is called, the Miscarriage of Justice Review Commission Act, also known as the David and Joyce Milgaard's Law, right? It's a homage to the efforts of the Milgaard. The bill was in fact enacted into law on December the 17th, 2024, which was the very last thing that the Senate of Canada did before prorogation of the Parliament, which led to, as you guys would know, a new election, a new prime minister, and what have you. So it was the very last bit of business that the Senate did, and the royal assent was given on December the 17th, which is the very last royal assent that the Governor General gave in the Liberal government of Justin Trudeau. And on March the 7th, the act became operational, which means that, in fact, technically, the Miscarriage Justice Review Commission exists, right? And it's there to now become operational. And in order to become operational, what has to happen is that there has to be an appointment of commissioners. That hasn't happened yet. And you can recognize that in the first half of this year, we had prorogation, and then we had an election. And then, after the election and the election of Carney, you've got the next 3 or 4 months of him dealing totally with the economy because of the Trump tariffs and what have you. So it's only been in the last month or so. So it's now November. So it's only been since September, October that the current Minister of Justice, Sean Fraser, has indicated that he, before the end of this year, is going to advertise through the Privy Council's office, the cabinet, to advertise for people to apply to become commissioners. And then once those positions are filled, the new commission will become operational. So right now, all applications currently go to the Department of Justice under the old system, but once the new commission is in place, all those applications at the request of the applicants can be transferred to the new commission, and I imagine all of them, in fact, will be. All right, so that's where we are, where we're at this point. All right. Fundamentally, the new legislation does two things. It establishes an independent body, so applications to the MJRC aren't to the Department of Justice any longer. So it's not to a department within the federal government. And it's not to the Department of Justice, which has responsibility nationally for criminal law in Canada, as you guys would know that under 91 under the Constitution Act, so Section 91. So the whole point is it's independent. So in fact, the head office is going to be in Winnipeg. It's not going to be in Ottawa. So that's to give at least the appearance that it's not connected to the federal government in Ottawa. So it's going to be in Winnipeg. And it's going to replace the review process basically on applications before it, right? So so the 696-1 application process will be gone, and you'll have the new process under legislation, right, to apply for an exoneration, right? And the test has been changed. So the test will now be for the new commission if they believe that a miscarriage of justice may have occurred, not likely has occurred. All right. So that changes the whole context of who's applying for an exoneration. You don't no longer have to prove basically beyond a reasonable doubt that you're innocent. You just have to basically convince the committee or the commission that a miscarriage may have occurred, and that will in fact then engage the review and the investigatory process that may well lead to, again, an order that there be a new trial or an appeal before the provincial court of appeal in the province in which the conviction took place. So the remedies are the same under the old system and the new system. It's either going to be a new trial or a new appeal. Right? That's the only jurisdiction the commission has. It does not have the commission directly to enter a verdict of not guilty. It doesn't have that power, and the minister doesn't have that power either. So it's the same remedies. Right? Now let's talk about the number of potential applicants to the Miscarriage of Justice Review Commission, and this is a totally prospect that's up for grabs. The first important factor to note, however, is applicants to the new commission are not restricted to just homicides. And remember, Innocence Canada only deals with homicides. And what that likely means, and again, I did this original slide before MJC was created. What this means is that other organizations than Innocence Canada have to be created to assist the wrongly convicted with non-homicide cases. And that is the remit of Miscarriage of Justice Canada. So basically, Miscarriage of Justice Canada will deal with cases that are homicide and non-homicide related cases, which means that we will deal with those 80% of cases that people will not be looking to Innocence Canada for with respect to assistance. Now, to get an idea of the possible number of applicants that may come to the new commission, What I did, and I've done this relatively recently, is look at other conviction integrity commissions around the world to see the kind of numbers that they see. This is applicants to their commissions, their innocence commissions. So we looked at the United Kingdom, which essentially is England and Wales, for the purposes of these numbers. We looked at Scotland, which has its own conviction integrity commission. Norway has its own commission, and New Zealand has a newly created commission. It's only about 2 years old. So we're going to look at those numbers. All right. So, and these are the numbers for last year for 2024. So in England and Wales, they had 1,400 cases come before their commission last year. That's a fairly consistent number. These numbers are all fairly consistent. Scotland, it had 300 cases come before its conviction review commission. Norway had 225 cases come before it, and New Zealand 155 cases per year. Now it's only been operating for 2 years, so that's the average of 2 years. All right. And then what we look at is the populations. So this exercise is essentially how many cases of wrongful evictions are come before a commission. So those are people who are applying to be exonerated. How many cases come before the commission in a year, and how many of those cases are a function of the population of where the commission operates. So in England and Wales, again, there were 1,400 cases per year. The population is just under 60 million people. So that essentially means that there's one application for exoneration for every 42,656 people. Okay, that's a fairly straightforward proposition. Same kind of exercise for Scotland, 300 cases per year. The population is just under 5.5 million. That means that out of every 18,220 people, there is one application for exoneration. Norway, 225 per year. The population is just over 5.5 million. So they have one application for every 24,785 people. And lastly, New Zealand, 155 per year for a population of just over 5 million. So they have an application for every 33,638 people. Okay, so hopefully everybody understands the logic in these numbers. All right. And if you take all of those together, so the average number of wrongful evictions in England, Wales, Scotland, Norway, New Zealand, if you add all of those numbers together, you get essentially 4 applications per 119,299 people, which is those 4 jurisdictions, which breaks down to one application for every 29,825 people on average over all of these other countries that have commissions that look at wrongful convictions. All right, now let's apply that to the numbers in Canada. Canada's population in 2024 was just under 40 million, 39,742,430 people. It's now almost 41 million as a function of a great amount of immigration, but the numbers we're working with here for 2024 are just under 40 million. So if you take that best estimate of the number of applicants per year for the newly created Miscarriage of Justice Commission, you take that 39 million or close to 40 million people divided by the average number of people the other 4 commissions see to create an application of 29,834, that equals 1,333 applications, which is an astounding number of possible applications that Canada will see once the commission becomes operational, which we estimate will be certainly in the first half of 2026 when the commissioners are in place, right? And they're actually accepting applications. I should also add, as far as the makeup of the commission is concerned, there will be 5 to 9 commissioners. This comes from the legislation. Of those, only one is going to be full-time. It has to be full-time and has to be in Winnipeg, and that is the chief commissioner. All right. The other 5 to 8 commissioners to be appointed will be a combination of full-time and part-time commissioners. The legislation doesn't say what that mix has to be. They could be all full-time, they could be all part-time, or a mixture of that. It also doesn't say if those applicants, whether they're full-time or part-time, have to be in Winnipeg. I would imagine that a number of them probably are going to be in Winnipeg if they're full-time, and I imagine the part-timers will likely not be based in Winnipeg, to be based across the country, hopefully. The legislation also indicates that it would be preferable, not mandatory, but preferable if some of those commissioners basically address the issue of the overrepresentation of Indigenous and Black and marginalized individuals in the system. So there should be, of those commissioners who are appointed, There should be, some perhaps a Black commissioner, Indigenous commissioners, women certainly will be commissioners. And but that's a preference, not something that's mandated. And it also requires that half of the commission are made up of lawyers who have experience in wrongful convictions. All right, so you're going to have half the commission who are lay persons, but again, who need experience in wrongful convictions, and half who are lawyers with that same kind of experience. All right, so back to the numbers, 1,333, right? And of those applications, basically, 400 of those will likely be Indigenous. All right, but that's an amazing number. And then go back to this. When I appeared before the Senate Committee, basically on Constitutional Affairs last fall, about this time last fall, when I was presenting these slides and talking about these numbers, the deputy chair of the committee, Denise Batters, she's conservative senator, but deputy chair of the Senate Committee dealing with Constitutional Affairs. She said that she was told by the federal government that they expected about 250 applications in the first year of operations. And she asked me where they got that number from, and my response was I have no idea where they got that number from. Nobody has ever released how the federal government came up with a calculation that would lead to 250. This number, 1,333, is the only number that anybody has ever seen that is actually a logical calculation of applicants based upon the applications to the other conviction integrity units around the world. And that's a lot, right? And and of that, if you think that 80% of those are non-homicide related matters, then potentially 1,000 cases will come to the commission in the first year, and it will repeat itself yearly for matters that Innocence Canada won't look at. So other conviction units like Miscarriage of Justice Canada will have to be looking at those. And those numbers are extraordinary, but that's possible. Again, this is all pie in the sky. Nobody knows. That's the best extrapolation of the numbers that we've come up with. All right. Now, dealing with the creation of Miscarriage of Justice Canada itself, it was founded as a federal nonprofit corporation. It was incorporated on January the 7th of this year to uncover the truth, obviously, and restore justice for the wrongly convicted. Right? Our mission is grounded in fairness, integrity, and justice, with a focus on marginalized individuals left out of existing supports, although we certainly deal with those who aren't in identifiable marginalized communities. Unlike Innocence Canada, which focuses on homicide cases, we will address wrongful convictions across a broader range of offenses, which obviously includes non-homicide related matters. We were created in response to the passage of Bill C-40. All right. We will prepare and submit applications to the Review Commission, the MJRC, advocating for exoneration where miscarriage of justice, and again, this is the operating term, may have occurred. Until the MJRC begins operations, we will assist applicants through the existing Federal Department of Justice process. So, we don't know when the MJRC will actually become operational. Depends on how quickly the commissioners are appointed. So until then, we're certainly there for people who want to still apply to the Department of Justice under the 696.1 process. And then when the commission, becomes operational, then we'll transfer it over to the commission. We filled the gap basically for those that are related to non-homicide offenses, right? So we're dedicated to do that. But our work prioritizes Indigenous, Black, racialized, and marginalized communities, those groups which are overrepresented in prisons, but vastly underrepresented amongst exonerees, right? We combine legal advocacy with public education, research, outreach to increase awareness of wrongful convictions in Canada. I could tell you as a function of outreach that we just received about 2 weeks ago permission from Correctional Services Canada to basically send our posters, and I've given everybody copies of those posters in your materials, to all the federal inmates across Canada, into the 56 federal institutions that exist. They gave us that permission about 2 weeks ago. It took about 7 months to get that permission, and the reason is quite simple. Correctional Services Canada is very careful about information that goes to inmates. They don't want them to be given information that is not transparent, that is not beneficial to their interests. So they certainly want to protect them from information that will not be of a benefit to them. And so it took a long time for CCS to agree that we could put our material into the hands of federal inmates so that they have something that they can use and take a look at and perhaps take advantage of. So last week we mailed just under 1,000 posters in both languages to those 56 institutions for distribution. They were directed to the inmate committees in each institution. So those are committees that are made up of both staff and inmates that work for the betterment of the inmates. And we know that they were actually mailed a week ago today. And they went out this past week. We know that they've been received because we've already received 2 applications as of yesterday as a function of those posters, right? And we have no idea how many more are going to come in, but we expect it to be fairly plentiful. But having said that, that outreach is now occurring. We've also had outreach to families of inmates. So I gave a presentation to Canadian Family Network of Inmates this past week, Monday evening. And so, all the families that basically are connected into a group, they know of the work we do. And in the event that an inmate, has a family member out there, that really works well for us because, they have access to the internet, so we can email back and forth and keep everybody current on what's going on. If we're dealing directly with an inmate in an institution, they don't have internet, available to them. So everything is done by way of Canada Post. So actually hard copy mail. Believe it or not, that still exists, right? So we have to mail, and it's very expensive. So we have to mail our contact form, which you guys have a copy of as well. We have to mail that. We have to mail our introductory letters and any materials that we need to obtain or at least seek to obtain. It all goes through Canada Post, which makes it a very cumbersome process, but one we have to deal with until the day comes that CSC allows inmates some access to the internet. All right. We also have partnerships with legal professionals, universities, as with PBSC, of course, Youth for Innocence, we're certainly happy to work with, other organizations we deal with, the Native Women's Association of Canada, the First Nations Chiefs of Police, all kinds of organizations we deal with just to make sure that we reach as many people as possible who believe they've been wrongly convicted and believe that their innocence will be shown if an application is made to the newly created Miscarriage of Justice Review Commission, right? And that's it. Okay, so let me just see what I can do here. I'll stop sharing, hopefully. There we go. So there we go. So we're not sharing anymore. Good. All right. So just for the purposes of everybody else, so the other things I've sent to you guys for your information are essentially the contact form. I can probably share that. Let's go back here. Sorry. Okay, so hopefully you can see this. This is the contact form. It's attached to the very rudimentary website we've created. We're having a much better one created now. But on our existing website, this contact form is there to be filled out. Again, if somebody has the internet, so this is going to be filled out by somebody who has family on the outside who can access the internet, and or what we've already done with the 8 clients, or most of the 8 clients we already have, is we've mailed this contact form in hard copy to them, and they've filled it out and returned it to us with the information on it. So as you can see, it asks for basic contact information, names and address, dates of birth, the institution where they are, kind of thing. We ask for names of friends or family if they have them, who we can deal with, basically, and then we ask for details of their conviction or convictions, and maybe more than one. The date of the conviction, the type of conviction, whether it was summary conviction or indictable. We also deal with dangerous offenders and long-term offenders, which the Miscarriage of Justice Review Commission Act specifically allows for consideration. We've asked for preliminary inquiry details, dates of the trial, basically what happened at trial, what the plea was, whether it was guilty, as in a false confession, or not guilty, that kind of thing, which court it went to, provincial court, superior court, if it's been in the Court of Appeal, if an application for leave has been made at the Supreme Court of Canada, all those kind of things we ask for. All right, these are details that are incredibly important. The grounds for appeal. Now, it's important also to realize that under the new legislation, the applicant doesn't have to have exhausted all of their appeals. So under the 696 application process, up until relatively recently, somebody had to basically go from the trial to the Provincial Court of Appeal and had to at least seek leave to the Supreme Court of Canada, which more often than not would be denied. They had to do that. But a case in the Supreme Court, about 10 years ago, basically indicated that, the Provincial Court of Appeal was sufficient for an application to the Minister of Justice, and a Supreme Court of Canada application did not have to be made. So, it's important that, and that carries through to the new process. The new process also indicates that all appeals do not have to be exhausted, but, clearly, if somebody's had a trial and has been convicted, it's very unlikely that the new commission will look at it if at least an appeal to the Provincial Court of Appeal hasn't been attempted. All right, at least they have to go that far. We also ask at the bottom if there's any new matters of significance that hasn't been shown. Again, that's no longer required. It's no longer mandatory under the new system, but obviously highly important in convincing the commission that an exoneration should be looked at. Okay. So let's see. All right, so stop sharing that, or let's see. What else can I share? Oh, okay. All right, so once somebody fills out that form, it's automatically put into our CRM. That's referred to as a client record management system, right? Which we have in place. We use that form, that contact as a Google form, and then it goes into a Google link into a sheet. And so the sheets are there, which have all of our clients to date and all the information that's come from the contact forms, right? And those forms can be edited by myself and other members of the executive staff, and by the students who are assigned to a particular file, right? So the students who are assigned to a file will have access to that form. So if we get information from an inmate that isn't complete, then the student will have that access to the form to complete the information with respect to particulars of trial and appeals and sentencing and what have you. Okay, so we'll stop sharing. There we go. All right, so that's basically it. So what's going to happen for those who are part of Western law is that come January, we will assign files to you, right? And then you'll begin the process of obviously making yourself familiar with the files, making contact with the inmates who have submitted the files. If you have any questions with respect to that contact information, and then we will start the investigatory process. We will start to see what grounds for the wrongful conviction are being advanced by the inmate, and then start to go through the process of collecting information or evidence that either substantiates those claims of innocence, or if it doesn't, will lead us to close that file and move on to somebody else. All right. It's still very, very early days. As I said, we've only been operational since essentially the beginning of September, but we have 8 active files right now. By the time we get to January, we'll probably have 20 or 30 of them. Right. That's our best guess, and so we'll divide those up amongst you students and take it from there. So, any questions at this point? Because we're almost done.
Hi, Mr. McMillan.
Hi.
That was an amazing presentation. It was so informative. I learned so much. So thank you so much for putting that together.
Sure, Mia. Thank
Um,
you.
I'm Mia. We've spoken over email, and then I also spoke with Rebecca. I'm the president of Pen for Justice at TMU, and then also the director of Youth for Innocence Canada. And I mean, I don't want to hold everybody up, but I did want to speak to you kind of quickly about some things that I think could be really great for kind of a collaboration between our organizations. We currently work on American cases, and so we haven't started working on Canadian cases yet. But yeah, I just wanted to ask if you had a few minutes to talk after.
Sure. Sure.
Okay, awesome. Okay, thank you.
All right. Thanks, Mia. Anybody else? No hands up? Oh, his hand up. Michael.
Yes, thank you, Miles. That was a great presentation. As someone who's very interested in criminal law, I'm a 2L here at Western. So I'm excited to uh, get to know the organization better, my colleagues, yourself, and to work towards some of these applications. I'm just wondering from a high level, do you know what the day-to-day responsibilities of us students might look like in the wintertime?
Where you're gonna be assigned files, and you're gonna be responsible for the information in those files. You're gonna be responsible for the contact with the inmates directly, which will more than likely be phone calls if they're incarcerated. It'll be email if they're not. We have a combination of those in our current files, right? And then we're gonna work with you to start, basically investigating the claim. And that's about as far as we're gonna get by the time we get to January.
And what might the actually investigating the claim look like? I know you mentioned gathering information based on particular claims that an inmate might want to bring, some evidence, if there's evidence that points towards their claim. If there's not, maybe we have to close the file, as you mentioned. What might that look like? Is that uh, in collaboration with police organizations?
It will, likely be contacting police. You'll likely be contacting the defense counsel that acted for the parties. We have we have a claim now that basically indicated that the person confessed to the charge but didn't understand what the confession meant, didn't think that their lawyer properly advised them, which is inadequate defense counsel, right? And so that involves, and then one of the things that we do, I should back up, one of the things we do when we get a contact form from the potential client is we send them two forms for their signature. One form is a release of information to us of anything that's relevant, and the other form is a release of solicitor-client privilege, so that we have the ability to talk to their defense counsel. And if they believe that their defense counsel was inadequate, then the investigation would include going back to the defense counsel and basically asking for their file, right? And everything's electronic these days, so we should get that file electronically, and then it's going to start basically reviewing the contents of the file to see what was done or was not done properly, and that'll take a lot of time, right? That none of these cases are going to basically go from beginning to end, quickly. So it takes getting that file. And firstly, getting the lawyer to agree to send it is going to be a challenge sometimes too. So sometimes we may have to bring applications to get those documents released, or we may have to write to the law society in the province where the lawyer practices to say, we want you to basically to tell this lawyer that we have release of his privilege. We want to help somebody with an exoneration. Please advise this lawyer that he has an obligation to help us. And they do. Right. So, all those are the kind of things that may well happen. When it comes to actual physical evidence, we'll have to work with the police to see what's happening there. We haven't been budgeted yet by the grant agency we're working with. Once we do, then we'll be able to hire investigators to actually work with us to uncover evidence that may well have been hidden. Those are the kind of things that you as students will be working with. And of course, any questions you have, if you had, hopefully each province through PPSC will have lawyers that are actively overseeing students. In the meantime, I'll be doing it until we do that. And I know that we're looking at an Ontario lawyer who's going to basically step in to oversee the Ontario students. That's part of the process going forward. But we don't expect that to happen until probably April. So, we're going to be working together, and all the students can email me directly, and I'll deal with you directly until somebody else steps in to basically overview the cases as well. So we're going to have, at the end of the day, we're going to have all the cases. We'll have both a lawyer assigned to it, which is going to be a volunteer, and a student to every case. Thanks, Michael. Anything else? Angelica, is there anything else you want me to say?
No, I think that's it.
Okay.
Thank you so much.
All right, guys, listen, thank you very much. I really, really appreciate you coming, taking your time out on a Saturday to watch this. And I look forward to working with you in a couple of months. Wonderful. Thank you.
Sorry, before we leave, Miles,
Okay.
I
Sure.
just wanted to, I'm not sure if you'll be in touch with some more information, but will there be some more training sessions before the holiday break?
No.
Okay.
This is
So
it.
everything then in the new year?
Yeah.
Okay.
All right, guys. Thank you very much. Take care.